We're live. We are live. Senate Finance, and we're gonna come to
Yeah,
order.
good things for you. I'll see you separately.
Okay, this is April 7th.
You kick you out of jail.
And today we are going to take up page 648. Banking, insurance, and securities. This is our first walk through. And is Maria not here yet? She's up there. Okay, Maria is on Zoom. Hi, Maria.
Hi, good afternoon, everyone. Maria Royal with Legislative Council. And I'm actually going to give just a few introductory remarks and then turn it over to DFR. So this is H648. It's an act related to banking, insurance, and securities. These are all proposals that were generated and put forward by the administration, DFR. You've already passed and the governor signed the captive insurance bill.
Yeah.
So there are about 59 sections, I think. It's 88 pages long, and it just seemed a lot more efficient to have DFR go through each of the sections and kind of the policy rationale for the suggested changes, and then answer questions as they're going through.
Okay.
So there were, and also just to clarify, there were no other, sometimes committees will take other bills and attach it to the big DFR housekeeping bill. That was not the case this year. So these are all proposals that originated with DFR. And I am aware of a few technical and clarifying further amendments that you'll hear about. So that's all I was prepared to do.
Okay, I think that sounds good. This is usually, they have been very good about keeping this as housekeeping. It's usually long and technical. Hopefully someone will give us a section by section before we're finished. So I have everybody on my list, starting with Commissioner Sampson. But Commissioner, this is your presentation, so you can.
I'm just gonna, it's okay, ask Joe to MC this.
Yeah, I think that would be great.
And yes, we will have a section by section for you once we have a chance to edit this and see whatever feedback you all have today. For the record, Joe Valenti, Director of Policy at DFR. I'm going to be the sort of cruise director, tour guide, etc. For the bill today. I'm going to share the screen. And if you don't mind, we are actually going to start in the middle with section 44. So there are 59 sections, as Maria had laid out. The first 43 all deal with banking, and the insurance and securities sections are both really short. And for securities, we have a couple of people on Zoom so that we could run through insurance and securities quickly. And then we'll start over at the beginning with the banking material. But we start with section 44. This is the formation of a mutual insurance holding company. And this is really about sort of what companies call themselves, how they market themselves, and their competitiveness. So there are different kinds of insurance companies. There are mutuals that are owned by their members. There are stock insurers. There are mutual insurance holding companies. We are clarifying here in section 44 that, and this is page 65, if you are following along. We're clarifying here the mutual insurance holding company may use the word mutual in its name, which was previously only reserved for mutual insurers. Mutual insurance holding companies have a more flexible corporate structure than traditional mutual insurers, with the ability to raise capital. And many of the prominent out-of-state companies that you hear of, Mass Mutual, Liberty Mutual, et cetera, that have mutual in their name are in fact mutual insurance holding companies, not mutual insurers. And so this provision would put mutual insurance holding companies based in Vermont on an equal footing with those in other states. We looked, and there are, I believe, 4 mutual insurance holding companies currently domiciled in Vermont. Some of the existing mutual insurers may be interested in converting to mutual insurance holding companies as well.
What does it mean to be mutual? I mean, I know in general, but in insurance terms, what does it mean?
Do you want to take that, Commissioner?
Sure. Commissioner Kai Sampson, for the record, a mutual insurance company is essentially owned by its policyholders.
Okay,
So I've presided over a demutualization when I was deputy commissioner, where the policyholders are essentially paid out on an acquisition for the value of, they converted it to a stock then gets sold
got it.
to a private company. So when you are a mutual insurance company policyholder, you have a voting right.
Essentially like a cooperative of
Somewhat.
someone. And
Yeah.
so then what is a mutual insurance holding company?
The reason that, and Joe gave some examples, the reason that is a popular way of doing business increasingly is that what essentially what it allows you to do is, if you are ABC Mutual Insurance Company,
Mhm.
you can't issue stock, you have trouble raising capital, or you're more limited in raising capital to support growth. And that puts you at somewhat of a competitive disadvantage with stock insurance companies. Mutual insurance company allows you to change ABC Mutual into ABC Stock Insurer, 100% owned by a mutual holding company. The policyholders retain the voting rights in the holding company.
Mhm.
The rating agencies look favorably on the ability, so you can sell some of the stock of that former insurance company,
Yeah.
mutual company. So just that ability to have access to capital, should you want to sell a piece of the original mutual, now a stock company, exhibits and it's very real, the ability to have some financial flexibility and backstops similar to a stock insurance company.
Okay,
Most importantly, you retain the original policyholders and new policyholders of the stock company retain the voting rights in the parent.
okay.
Okay.
So it's kind of a way of having your cake and eating it too.
Exactly.
In insurance terms. Okay,
Yes.
awesome.
Yes. And again, I think it's important to understand that we're not out on a limb on this. This is something that had not been addressed in law, but other states do it. And, our mutuals would appreciate if they ever go down that route, the ability to also continue that mutual when the rights and benefits for the policyholders remain the same. It's just a different corporate structure.
It's a trend that's gone on for 30 years or so, right?
Yes.
It's just not something that,
We're 30 years behind. Okay. Thanks.
so, thank you.
And basically it allows them, it makes it easier to raise capital.
Right.
Yeah.
So that was section 44. Section 45, this will be very familiar from the captive insurance bill, H649 that we did a few weeks ago. This is codifying our existing electronic filing requirements. This was a recommendation that was made by the National Association of Insurance Commissioners during our recent accreditation exam, and it has an explicit process for filing quarterly statements with the NAIC. So this is largely the same language that we had for the captives. Setting what the quarterly deadlines are. And that's 45. Section 46, so this is page 69, clarifies when dependent coverage can be added to a group life insurance plan. So this one, the existing language here was enacted in 1993, and we were not able to find the exact rationale. But the idea here is that if you have a group life insurance plan and any part of that plan is coming from employee funds, Whether that plan covers dependents is contingent on how many employees are a part of that plan. The existing language makes coverage contingent on 75% of eligible employees or members with eligible dependents. Here's the language that we are striking out, opting into coverage. So you would need 3/4 of the employees or members with eligible dependents opt into dependent coverage, and then they're able to offer dependent coverage to everyone. But it's an impossible calculation to make if you don't know how many employees or members have dependents. And so to correct this impossibility, we change the threshold to simply require that 75% of eligible employees or members opt into coverage, regardless of whether they have dependents or not.
That's much more equitable.
Yeah.
Too.
Yeah. So that, and again, we don't know why it was structured that way. This is not, this was not based on a model law or not something we had seen elsewhere, but we thought it was worth clearing up. And then the last one here for insurance was, again, well, a couple more that we'll come to later on. So section 47 on page 70, we're adding, and just need to scroll to the right section here. We are adding race, religion, and national origin to the definition of unfair discrimination in insurance underwriting. Previously, the statute only explicitly covered, as you see here, sex, sexual orientation, gender identity, and marital status. DFR's interpretation of the statute already included these terms, but they were not explicitly here. We thought that was an oversight. So any questions on insurance?
Not seeing it.
Let's see the bottom of that, section B.
Oh, sure.
Okay, I'm great. Let's look at
All right. Last call on insurance.
Okay. First day for the pages. They're all very long.
I've been here a year and I'm still lost. I appreciate that. For the first few security sections, our deputy commissioner was not feeling well today, but I will turn it over to Noel Hudson, who is on Zoom. He's currently with the insurance division, but was working for the securities division when some of this language was written, and he will do sections 48 through 50.
Okay.
Yes.
Yeah.
Greetings, everybody. Can you hear me?
Yes, we can hear you. Okay.
Hello. Okay, so for the record, my name is Noel Hudson. I'm the Director of Insurance Regulation. As Joe mentioned, I used to be working for the Securities Division. Happy to help Deputy Commissioner Amanda Smith out today when she was unable to be here. So starting with Section 48. This is the so-called, this involves the statutory reference here is 9 VSA 5202 subsection 14. And this is the so-called de minimis exception. What this statute is intended to do is to basically exempt from any sort of filing transactions that are deemed to be sufficiently insignificant that they hit all the criterion, and they don't have to file with us. They don't have to notice file with us. They don't have to file for an exemption with limited filing. They can just not contact us at all. And we've discovered two aspects of this exemption that were a bit problematic. They're two, for the purposes of this conversation, they can be addressed totally separately. The first is the threshold of 25 purchasers within the state. We recommend shrinking that down to 10. That is a number that is much more in line with other small securities markets across the U.S. The overwhelming number of states use either 25 or the 10 threshold, and as you can imagine, the larger states would go with 25. In Vermont, it's much more appropriate to go with the 10 threshold, simply because we are such a small securities market, and any offering that is roping in more than 10 investors in Vermont is fairly significant market activity that we don't want to be giving people blanket exemptions from our regulations over. So that's fairly straightforward. The other piece of 5202 sub 14 that is in need of revision is we adding a section to take the exemption away from availability for Rule 506 offerings under the federal regulation D. These are the so-called private market offerings. These are very large. This is part of the market that's really exempt from public trading. It tends to be very large offerings, very well-heeled investors, and there's a lot less investor protection. We do require, as every state does, notice filings when Vermonters are investing in one of these offerings. But the problem is that this 520214 exemption was applying to those notice filings, and we needed to fix that. We have the rule for Rule 506 offerings is that a notice filing is due to the Securities Division 15 calendar days after the first sale in the state. That is the rule that is followed by the overwhelming number of U.S. jurisdictions, in excess of 50, because we're talking about, in addition to all the states, we're talking about Washington, D.C. and Puerto Rico and Guam and places like that. Everyone pretty much follows the 15 calendar days first sale rule. And we have been for a long time, and we intend to continue with that. And so to the extent that this exemption exempts those offerings from that rule, we needed to add this section. There is one additional detail. Oh, sure.
Yeah, I'm sorry. I think what you're talking about, I just want to make sure I'm clear, is on page 72, paragraph big B, capital B. Is that the?
Yes.
Okay. Because you said a couple different numbers, and I think you've
Yes,
said.
we are talking about 72 underscored language with sub B. That's correct.
Yeah, okay. Because you said 5202 and this is 5302. And I just wonder, is that an error or is that, did I mishear?
Well, there's an internal reference to 5302 there, and that was that's the notice filing statute. There's all the cross references get a little
Down a little bit because we can't. And the last thing we can see is the 5302.
Yep.
Okay,
Okay.
so that's the section. So, okay, the 5302 is just a notice requirement. So where does it say it's exempt from 5202?
At the
well,
top here.
if you read the whole sentence, and yeah, we're talking about amending section 5202.
I see.
Okay.
That emendation has a reference to 5302 in it.
I see. Okay, I just wanted to make sure that there wasn't a little Scrivener's error in a number there.
It's just numbers that rhyme, if you will.
Yeah. Those can be problematic though.
Yep.
And you need to be precise.
What
Although, while we're on the subject,
Here-
there was a little Scrivener's error that we were also hoping to address with the Senate, which is that this reference to 5302 actually needs a sub C next to it. That's getting the statute to do it. What's that?
I had a feeling there was a problem
Well, your instincts were right.
there.
That we are looking to amend this by adding 5302 sub C of this title at the end there.
So this is the days before. What are we changing in this? Is it the days you need to, because these aren't regulated by us, but you get a notice? Are we changing the notice timeline? What are we changing?
So, well, ideally, we're not changing anything. This is this problem in the statute that we're addressing flew a little bit under the radar, and it was discovered a little bit by accident. That's a very long story. We're not sure how much of the industry is paying attention to the fact that this exemption currently applies to Rule 506 offerings. We get many, many filings from filers who clearly are not aware of it. So it may result in a small number of increase in Rule 506 notice filings. We're not sure what that increase would be. It certainly wouldn't result in a decrease.
And those filings are what? Rule 506 filings?
These are notice filings for Rule 506 offerings.
And Rule 506 offerings are what?
big words,
Okay. Okay.
right?
These are, yeah, these are
Private
regular, these are,
market,
sorry,
Private market offerings, right?
these are the so-called private market offerings. That's something of a misnomer because they've expanded greatly in importance, and there's a fairly large de facto market for these private market offerings.
Okay.
But this. So they file, right now. They're required, we don't supervise. They're not under our jurisdiction.
They
What-
are
See.
they are preempted by federal law from being required to register with the states, but we are still allowed to require notice filings for them.
Okay, so,
But there's a conflict, I think to put it simply, there's a conflict between the statute and the regulation about whether they are required to file, am I understanding, or exempt from filing?
That's correct. And we have intended to require them to file on the 15 days first sale rule, just like all the other states. We've been doing that forever. That's in our regulation. But at some point we noticed this statutory conflict that we needed to fix.
okay, so we didn't put the 15-day in the statute like all the other states. But most of them have been filing? Or not?
Yeah.
Okay.
Some states impose that 15-day first sale by rule. Some states do it by regulation. We do it by regulation.
Okay. And it's a notification they're filing that we're offering this to people in your state. So
That's correct.
federal law doesn't let us regulate it, we just think
We still have anti-fraud jurisdiction over these offerings if someone is alleging that there's a securities fraud issue there, but we can't require them to register up front.
okay. Just fix it after the fact.
And then that change to 5302, again, in line 12, we'd be looking to change that to 5302C. Initially, we had all of 5302 included, and after further review, we realized that would be overly broad and would cover more than what we would seek to cover here. 5302C targets the exact.
Just make sure you get that to Maria and.
Yep,
you have
Maria's
it
already got it.
and we have an amendment,
Yep,
all right,
and I think we only have a couple other of those that have come up through our review.
okay. Truly housekeeping,
Yep.
okay, we can keep going.
All right, we get on to section 49. Okay, hopefully these will be simpler. The first change we're requesting here is to strike portfolio or from the text. We believe that this portfolio or share class, that's giving, we think that's variable language from the original Uniform Securities Act. We've been requiring filings by share class for, within living memory of everyone working at the securities division, and that's what we intend to keep doing. But we need the statute to line up with the rules we were actually using. And so giving our regulated entities the option to file less than we intend is what we're trying to prevent here. It's not a practical issue on a day-to-day basis. It's not the kind of thing we almost ever get a call about, but it's just a piece of clarity we need to add to the law. And then the other second amendation to this section is to add that these fees are non-refundable. All our fees in the securities division are non-refundable and have been for a long time. We've discovered that if you don't say that absolutely everywhere, we wind up getting phone calls, and we just want those phone calls to go away because you get regulated entities just looking at the piece of the statute that applies to them specifically and saying, and when these fees are non-refundable isn't there, they start asking questions, and we want to keep the statutes as clear and consistent as possible. On to section 50.
Yes.
All right.
Oh.
So in section 50, we have two issues. The first is at the end of subsection B. We noticed one day this language about open-end investment companies. That's another notice filing entity, and not a registration. This is a statute about registration. open-end investment companies do not register. So we're quite puzzled regarding why this language was here. It's probably very old. It probably dates back to the day when the filing fee of $600 was equal for both types of offerings, for registrations and for notice filings. Those days are long gone, and it just doesn't make any sense for this language to be in this statute. It's a statute about registration, and open-end investment companies don't register; they notice file. So we just need to have that sentence struck. And then moving down to subsection K, again, the fee is non-refundable. That's for the sake of clarity and efficiency. That is not a rule change. That is how it has always been, but we're just trying to make it as clear as possible for our regulated entities.
Okay.
Any questions for Noel on those three sections?
I do that. So quick question. Do some of these companies think the fee is refundable?
It's not something any represented company has wanted to start a fight with us about. It's the kind of thing that paralegals get confused by.
Oh, okay.
I
Yeah.
never ask. Yeah.
And mid-level managers try to find wiggle room with, and the answer is always no when they're giving us those calls, and we're just trying to get rid of those calls.
Got it.
30 use of our time.
Yeah.
Okay.
All right, well then I am going to take the next couple of sections before handing it over again to the Zoom. So section 51, this is very simple. This is changing the Washington County Superior Court to the Superior Court of Washington County for consistency. And we made that choice in two different places. Initially, I think we had done it in one spot in this paragraph and not in the other, and it should not be consistent. So section 52 similarly is very simple, corrects a typo in the reference to the definition of a vulnerable adult under the Adult Protective Services statutes. That's supposed to be section 34, not section 14. That's just correcting the typo.
Protective service and after the insurance.
So this is about being able to increase a civil penalty for violations involving a vulnerable adult.
Okay.
And so
Okay.
vulnerable adult is defined in the APS statute, and we were just referring to the wrong section.
Okay.
Then section 53, I will hand it over to Jennifer Root for DFR.
Good afternoon. My name is Jennifer Root. I'm one of the Assistant General Counsel at the Vermont Department of Financial Regulation. The requested change is to section 9 VSA 5604(e), and it's intended to codify essentially existing practice. This is a penalty provision, and under the current statute, the commissioner has discretion to consider other factors in addition to the handful that were enumerated. But the other factors are not spelled out, and we wanted to make it clear that the commissioner always considers equitable factors. In other words, those intended to protect the public welfare rather than solely to punish, and make sure those were spelled out in that section. And the reason it was brought to our attention in summer of 2024 when the U.S. Supreme Court handed down its decision in SEC versus Jarkissi. And that was a case involving the SEC seeking civil penalties in a securities fraud case. The defendant sought a jury trial under the 7th Amendment of the U.S. Constitution, and the court found that the SEC's penalty provisions were primarily punitive in nature rather than equitable. There were some other things going on in the case, but for purposes of this, they looked at the nature of the penalties and found that the defendant was entitled to a jury trial. So then we looked in Vermont, if this issue were raised, it would come up under the Vermont Constitution, which is slightly different than the U.S. Constitution, but not that different. And we looked and found the Vermont Supreme Court had considered this essentially almost this exact issue in looking at cases under Title 10, which is the environmental penalty provisions, and Title 30, which is public utilities, and found that the factors that were spelled out in those penalty statutes were primarily equitable in nature, so that a defendant wouldn't be entitled to a jury trial or respondent. So we thought it made sense just to spell out the equitable factors and make them identical, with the exception of the first one, which is subject matter specific, but the rest of them to make them identical to the factors enumerated in Titles 10 and 30. It matches what's actually happening with if we have a significant case involving penalties, the commissioner does in fact consider all those things. And just to make this enforcement of securities laws more efficient, we don't want people to be requesting jury trials in administrative cases, in the department's discretion. So that just for your information, if you need to know, the sections of Titles 10 and 30 that are relevant are 10 VSA Section 8010 paren B and 30 VSA Section 30 paren C. So that's what we think ought to happen, and I'm happy to answer any questions.
Okay, so there was a Supreme Court hearing, FCC, and the determination was that the fines were punitive, not equitable. And
Correct. And the court looked at the SEC's penalty provisions and how they were used and found they were primarily punitive. They also found that the case was one that was similar to what would happen at common law, rather than this is not particular to the penalty, but they found it was a case similar to common law during which a defendant would have a right to a trial by jury rather than a proceeding brought by an administrative body, which is somewhat different. That's not what we're really talking about here, but just for context.
so we are enumerating the criteria here so that the equitable sections are there and clear, so
Correct.
that you get an administrative, I guess, challenge or dispute, that hopefully you won't have a common law decision that dispute goes to a jury trial. That basically.
Right. I mean, the commissioner is already considering these types of factors. We just thought it made sense in light of the other penalty provisions in similar statutes in Vermont. It made sense to spell them out so that we don't have misunderstandings and we don't have to litigate the question of what the commissioner is doing and whether someone's entitled to a jury trial.
Okay, that is helpful.
Any questions on section 53?
Okay, I'm not seeing any.
All right, thank you, Jennifer.
Thank you.
Section 54, I'll take the next handful, and we are almost to the end of the bill, and then we can start over again with Megan. So section 54 makes several clarifications to the Vermont Financial Services Education and Victim Restitution Special Fund. This is a fund that at DFR that comes out of enforcement activity and can be used for restitution, for whistleblower awards, for financial education. Our grant program disbursements come out of this fund as well. So we are specifically, we're amending some definitions of a claimant and a dependent child. The definition there is matching the federal tax code, and a vulnerable adult, which is again matching the APS statute. It limits restitution assistance to Vermont residents at the time of violation, provides for confidentiality of applicants for restitution assistance, and it adds language on state subrogation rights conforming to the NASA restitution assistance model package. This is so here we have the confidentiality provisions here on page 79. And then we have the subrogation. Against the person who is ordered to pay restitution. And then we do have this final section here on forfeiture of a restitution award. So someone was engaged in dishonesty, forgery, fraud, or deceit in connection with an application for restitution assistance shall forfeit any amount that's paid in institution assistance.
Okay,
Um. I'm not sure I'm understanding this. This is for. Trying to protect people who are the victims of some kind of financial services fraud.
So if, generally speaking, if, there were an enforcement action, in the securities division, and, the company that had broken the law was insolvent, wasn't able to make payments to victims, we would be able to make payments out of this restitution fund. It's usually a fraction of what people lost, but it is something that they're able to get if they're not able to get redress directly from the company that.
Can you give me an example of what kind of crime would have been, or can you give me an example of this situation that what would have happened?
I don't have one on hand.
Hi, Sampson, Commissioner. I can share with the committee an order posted on the website that gave rise to restitution. But the
Okay.
parameters are securities violation. So it actually doesn't apply to insurance or banking.
Okay.
Enforcement orders. It has to be an enforcement order that ordered the company to make restitution. So that could be, you procured investments without registering properly. You
Okay.
took money from Vermonters who lost money and you didn't go through the proper channels of approval, review, et cetera, either federal or state law. So in order to be, qualified for the restitution, it has to be ordered restitution and the guilty party is unable to pay. It's
Okay.
not paying. I was actually just looking it up, so thank you for the question.
Sure.
And I think since 22, we've paid, it looks like almost $400,000 in restitution to Vermont
From this fund?
from this fund.
And how does money get into this fund?
When it gets into this fund, in any of these areas, insurance, banking, or securities, we do an enforcement action that ends in a stipulation and consent, or actually, it'd have to be a stipulation and consent, I believe, because it has to be voluntary on behalf of the entity. So the entity is made aware that we're going to fine you for what you did, but might also order restitution. They have the option to put up to 15% of the total penalty into the fund, which also funds financial literacy and outreach grants that the department has given. So it's actually
It's the restitution, education, and whistleblower.
yes.
Wow, okay,
Um,
cool. Yeah, if you could send one as
Sure,
an
yeah,
example,
see if
that
I
would be
can find
helpful
one.
just to understand what this is.
But I think my memory is correct that the last major one was soliciting investments from Vermonters without going through anywhere near the
Wow.
proper channels.
Okay.
so what's for makeup stuff?
Sure.
Yeah.
It's that same, it would be that same category but at the state level.
Yeah,
Where there is, there's a violation and there are not the funds available to pay that. And it's a percentage, and there's a higher percentage if it's a vulnerable adult. That's what I'm betting is. Anything else on,
what is,
oh, go ahead.
does it mean a natural person? What does that mean? specifically?
Not a corporation.
No, okay.
I mean,
Okay.
yeah.
That would make sense.
That makes, I always forget that
Yeah.
corporations are considered people.
I
Yeah.
All right, so I'm going back to. Next is page 81. We have a few miscellaneous items here before we get back to banking. So this is section 55. Pages 81 and 82. So this was a fun one. We are removing a duplicate fund from statute. So existing section 19 in Title 8 provides for a financial institution supervision fund, and it also provides for a banking supervision fund. as you see in subsection G here. In practice, we only have a financial institution supervision fund. We checked, there is no money in the banking supervision fund. It's not a separate entity. There's nothing there. So we are renaming the banking supervision fund to the financial institution supervision fund so that both are referring to the same place.
And deleting the banking fund.
Yes. I believe this is the only reference to it. Was in this
Did you
subsection.
say that was on page
That is page 82.
82? Okay.
Yep.
All right.
Very similarly, you'll see section 56 at the bottom of page 82 and section 57 on the next page are connected. So we are moving the insurance regulation and supervision fund from its current location in section 80 in chapter 3, and we're moving it to section 3317. The reason behind this is to clean up Title 8. The insurance fund was the only item left in chapter 3. Everything else in that chapter has already been repealed or moved. And chapter 3 is also adjacent to banking language. So just in terms of pure housekeeping, we would have the fund for each division would be next to the chapter governing that specific division.
I love that. I like getting it like lined up.
Yeah, so we had a debate about do we put all the funding pieces in one place or do we put them with each division, and we're putting them with the divisions. This is the one that was missing. And so it will be in its own administrative chapter at the end of chapter 101. The other piece here in section 56, we found some outdated language, that we are repealing, which was enacted in, I believe, 1967, when the age of majority in Vermont was 21. So there was language allowing mortgage loans to a married couple if one or both were considered a minor, which meant that they were 18 or older, but under 21. We no longer need that unless the state looks to increase the age of majority again. In the future, there is no need for that statute.
Does it also use the terms husband and wife?
Yes,
And you got rid of that?
yes,
Okay, that's
yes,
good. A lot has happened since then.
yes. This is why we periodically take a look, and Ledge Council is extremely helpful in looking at these statutes and finding the things that maybe we don't need anymore. So
I don't think we've gotten rid of the one about in divorce, you get to keep 3 chickens and 5. I think we've kept that for nostalgia.
For nostalgia, the chickens.
It's come
Yeah.
up in, it's quite an extensive list of what I believe the wife has to be left with.
Sound like foul play.
I only have one.
So, and then section 57, again, this is just taking the language that we had taken out of chapter 3 and put in chapter 101 about the insurance regulatory and supervision fund. This is exactly what had been in the other location. And then the last piece here is we are adding in section 58, this is page 84, statutory requirement for registered investment advisors to maintain cybersecurity insurance with criteria to be established by the commissioner. These are requirements that we implemented in our securities regulations back in 2016. We just wanted to codify them in statute. And so that is all we're doing here.
These are all federal requirements that you're codifying in.
It's subject to I believe the federal references are about the registered investment advisor definition.
Okay.
But so we have in our state securities regulations, we have cybersecurity requirements. And we're just placing those in statute.
That's kind of relevant these days.
Yeah.
We just need it.
That would be useful. And then the last, and here we go. in F, we have the adequate insurance for the risk of a cybersecurity breach, and those are requirements may be established by the commissioner. And then the very last thing here on page 88, the effective date for everything we have here is July 1st of 2026. So that is it for the non-banking portions of the bill.
The banking was going to take up a lot of space.
I don't know if you want a stretch break. There is some duplication in the banking parts, that some of the sections are repetitive, and so I don't think it's as daunting as you might imagine, but if you want a stretch break, we can do that, or we can.
I think they'd probably rather get out early than do a stretch break.
All right. Well, in that case, I'm just going to step aside here. I'll keep scrolling, sharing my screen, but I'll hand it over to Deputy Commissioner Fenness.
Thank you.
Sure.
All right, this is the newest one. Please do everything I can to remove the president from office.
Do you have that power, Chair?
Wow. Well, the Secretary of the Senate said I was all powerful.
Well, there you go.
I thought it was limited to this room.
May it be so.
I don't know how much more to actually. Okay, let's see how much power we've got over banking.
All right, good afternoon, Eric Barretts, Deputy Commissioner for Banking at the DFR. So we will go back to the beginning of this whole bill. Just a quick, the theme within the banking portion are really, we're trying to align definitions as they're used throughout Title VIII. So for example, in many places, we use the term financial institution, and in various sections, it means very different things depending on where it's used. So what we've done is we've codified. So we mean, when we say financial institution, we mean bank. If we mean something else, we've used a different term and we define that other term. So starting off on the right at the get-go, section 1, we are clarifying that for a license, this is in chapter 72, which is our general licensing provisions, which apply to all of the entities that need to get a license from banking division. We're making a specific clarification that a consumer litigation funding company actually needs to obtain a license from us. It currently reads that they need to obtain a registration. Our lawyers tell us that there really isn't a difference between a registration and a license, so we like to just call everything a license for consistency's sake.
There's a difference in OPR, so there might be a difference here.
According to my attorneys, they say that they would prefer it to be a license.
Yeah.
So there is one amendment we would like to propose here. That's on page 2, line number 2. There we left in the word registration, and we want that actually updated so it reflects the license change.
The license.
Yeah,
Line two?
correct.
There are two registrations.
Oh, the one before.
Yeah, the one before, sorry.
Well, you are on the
I
ball.
I love these boring bills. They're really,
I wrote the bill and I didn't say.
I said I love them. I like,
It's a little boring.
it's boring, but
exciting.
it's like, if you dig into it, then it's kind of interesting, actually.
Until somebody sues you, it's.
Yeah, yeah.
You have the reporter of the film.
Page 2, line 2.
Oh, it's page 2.
I see it now. I skipped right.
Perfect.
Dropped
Yeah,
it.
the first instance, sorry, you did put it in our notes, the
Yep.
first instance. Saying page 2, we're in section 2 now. And so we're adding language so that when DFR is reviewing whether to grant a banking license, that the commissioner must determine that it is in the public interest to permit the applicant to provide services in the state. We also needed to clarify the types of corporate entities. They added gender neutral language. And then also again, clarifying that a consumer litigation funding company is getting a license. Section 3, this is about change of control. So if an entity is owned in one structure and someone would like to buy it, that would be a change of control. We're adding clarification about you need to provide us notice if you're seeking to control that entity. And it strengthens the standard for that, of a money transmitter license. And we added some conforming changes, to this section that conform with something called the Money Transmitter Model Act, which we codified 2 years ago, in the banking division. And this was just something that we omitted from that codification. So we're adding this, in here. And there was a specific reference added to commercial lender licenses as well. Section 4 refers to the annual renewal of license, just minor clarifying changes to the statute.
Wait, can I ask,
Absolutely.
on page 6? On paragraph E, unless exempted by subsection F of this statute.
Correct. So if you go to page 7, we've added subsection F, and that is the money transmitter language that I'm saying we omitted from when we codified
Oh, I see,
the
okay.
money transmitter.
I remember we passed that, and this is bringing the regulations in line with the bill, the updated bill. It was a model law in AIC.
That is, right, that's the banking sister organization in AIC essentially, yes, it was a language that we omitted from that model act inadvertently.
Got it.
Let's see, where am I at? So let's talk about section 4.
Section 4 is page 9.
Section 5. This is in the statute where it gives the commissioner power to revoke, suspend, terminate, or not renew a license. We've run into some situations where after an entity is applied for their license with us, we've learned that they've had trouble in a court of law, to either pled guilty or with no contest. We'd like to add language which would allow us to take an action against that license without having to license them then take action.
What if so this is just about pleading guilty or no contest, what if they've been convicted?
Then we already have those powers.
Oh, you are.
Just completely denied. So yeah, this is, if you look at line 13, it says subsequent to the date of application. The licensee is convicted of or pleads no.
Oh, convicted is already in there, sorry, you didn't see that.
And then we've added some language that strengthens we've added reference to their financial condition, responsibility, and financial and business experience. Competence, character, etc. Does not command the confidence in the community. It does not warrant belief that the business will be operated honestly, fairly, and efficiently.
Oof, like that. Confidence of the community.
Let's see.
Page 11, the,
Bottom of page 11, section 6.
before you get, subsection B, if commissioner refuses to renew a license.
Sorry, I lost my joke. Oh,
Page 11, yeah.
there you go. Yes, so we've added section D 1, 2, 3, 4. And we've added essentially due process ability, so that this would be the process the licensee would go through if we did take an action. Bottom of page 11 in section 6, that is examinations and investigations fees. Excuse me. Yes. So this is clarifying that the data that we obtain during or for an examination or investigation is confidential. And that also, we've added a reference to reports required pursuant to section 2120 of this chapter. And that is what we call call report data. So that is data that entities report to us what they're doing in Vermont. So we would like to make that confidential. Let's see, sections 7 and 8 are specific only to the consumer litigation funding company licenses that I referenced earlier. A lot of the changes here are again Instead of referring to registration, we're referring to it as a license. And then we also just added clarification in paragraph B there on in section, excuse me, page 12. In addition to the information required by section 2102 of this title, an applicant for a license shall provide, and the licensee shall at all times maintain the information that's still existing in the statute. Any questions to section 8? Okay. Moving on to section 9. These statutes are in the actual money transmission license area. So we have made a number of changes, and sections 9, 13, and 14. What we've done is we've moved some of the virtual currency definitions from other parts of the statute forward into the beginning. So all of the definitions used are in the definitions section.
So this is just cleanup on the virtual currency stuff.
Mostly cleanup, yes.
Okay, so did we do that virtual currency bill last year, the kiosk? Okay,
That's what got attached to this bill last year.
that's what I thought. And I heard, I think we were talking about it here one day. There've been some,
There's been some activity lately, yeah.
yeah,
In New Hampshire, they've got a lot of problems recently.
yeah.
I've heard that in states where they have a lot of machines, they have a lot of problems.
Yeah,
Because of the laws that we passed, there's only 2 machines in Vermont currently. So less machines equals less problems.
yeah, but didn't we last year in that bill include provisions that might lead to more machines? Cause we got rid of the
Yeah,
cap, right?
so, yeah, we've had a registration requirement. And then there was added 2 years ago, there was a mandatory moratorium.
Right,
Approving any new machines, so only existing machines were grandfathered.
right, and we got rid of that moratorium, so,
The moratorium was extended through this year and it does expire June 30th of this year. So unless the moratorium is extended or some other action is taken, we will begin on July 1st accepting applications. Now, last year, we did strengthen the consumer protection statutes.
I
which is
thought
what
there
I
were
think you're-
conditions on that moratorium.
Other states have actually gone further than that with bans.
yeah, well, I'm wondering if we might wanna have this conversation again, cause I'm concerned about. I don't know if you all are concerned about it, but given what I've heard has happened, I'm not sure we want that.
We
Yeah,
should look
like I
for
said.
this stuff. Hear what is going on nationally.
Sorry.
Yeah,
I said we should hear what's going on nationally, if there's been problems.
I know Indiana's governor just signed a bill that bans the machines in the state of Indiana, I think 2.5 weeks, 3 weeks ago. Tennessee and Minnesota, I believe, are also working on legislation that would ban them. Just for an example, I think Kai and I were talking about this the other day. The 2 machines in Vermont accounted for like 0.4% of the crypto activity undertaken through our licensees. So a very, very, very small amount of activities going through these machines right now. So if there were to be a situation where there were no machines, consumers still have other ways to access.
and the machines are problematic. In other states are banning them because of like criminal activity that's happening through the machines or at the machines.
A lot of concern with the machines have been about scams. You've probably heard the horror stories of, the grandmother being given a stool so she can sit there and just feed $100 bills in the machine. Since a lot of states don't have any limits on the amount of transactions, Vermont currently has a limit of $2,000 per day as customer.
That could really add up.
That's
for
still a
somebody.
lot of money.
Yeah,
A lot of Vermont.
given that we have this as a vehicle, I would like to hear more and see if we might want to do.
Definitely agree. Let us know when you can be ready to come back and talk to us and.
We'll just say the word, we'll have somebody here.
And what's this bill doing to the crypto machines, kiosks?
This isn't really doing much to the kiosks, like,
Okay.
there are some changes that I'll get into, but like I said, mostly we've just moved definitions from parts of this money transmitter statute forward to the definition section. So there's language where we're added on page 14, for example, the definition of exchange. That's not new language, that's just found elsewhere, which you'll see where we've stricken out. The year on page 16, definition number 19, money transmission kiosk. So the cryptocurrency kiosks that we were just discussing are a form of a money transmission kiosk. We've just expanded this definition in anticipation of business models. So like, let's say, for example, Western Union wants to put in a machine where you can actually, use the Western Union network to move money from here to your son's college in California, for example.
Through virtual currency?
Not through virtual currency, just through money transmission. So right now you can go to the drugstore and give them $200 and they will, through Western Union, give access to whomever you want that to.
Yeah.
So this would just envision if a company set up a money transmission kiosk to do that, it would still need to be registered to us. And this clarifies the definition of that. And it, like I said, it does include any virtual currency kiosk.
Not all kiosks are the same.
That's correct. On page 19, this is an example of additional language we move forward, which can be by transfer. Page 22, there's the definition of a virtual currency kiosk. Paragraph 34 there, virtual currency kiosk operator means a person that offers, facilitates, or engages in whole or in part, directly or indirectly, virtual currency business activity. So we've strengthened that definition a little bit, but that is I think needed. And then for final definition there, number 36 on page 23, virtual currency transaction, that language was moved from elsewhere in the statute. In section 10, I mentioned that we were trying to clarify the use of the term financial institutions. So on line 17 there, we've made it clear that we've added any financial institution or credit union to that to make it clear that the money needs to be in a depository institution. Let's see, on page 24.
When you say financial institution, it means bank, unless you state otherwise.
Unless we state otherwise, exactly. So here, we're saying that
Bank or credit union.
we envision a money transmitter can use the services of a bank for a credit union to hold those deposited funds. So on page 24, we're now into section 11. And this is the section where we get into the money transmission kiosk registration. And we've adopted a little stronger use of the language about how that is offered through those machines. And it does require the registration that meets that definition. Page 25, that last paragraph there, with clarifying the information that we need during that registration process. So that the kiosk machine itself does state who the actual licensee is and not the owner of the kiosk. We found situations where the licensee conducting the activity, the kiosk itself were different. And so we want the consumer to know the licensee, because that's who's regulated by us directly as the licensee. So we've added that clarification for that section.
So there could be a New England company that was leasing kiosks to
Exactly.
all right, Bitcoin.
You could essentially avoid the requirements by having a separate entity own the machines and then renting them out. Let's see, where am I at? All right, section 12 is on page 25. This is again a situation where we've added a clarification or credit union to the term financial institution. And this is specific just to check cashing and currency exchange activities. Another change to name on page 26. Section 13, this is on page 27. This language we've stricken because the language is not needed now. We've moved it forward and provided it in other areas. Section 14, this is that sort of sub-definition section that we've moved forward. You can see all the language that's been stricken. That's because it was moved forward. So any questions on the money transmission section other than what we've talked about with the kiosk issue? If I'm speaking too fast, please tell me to slow down.
These sections are struck because they've been moved to somewhere else in the statute.
Yes, the language in that section was moved forward, correct.
Okay.
That way all definitions are all in one spot instead of
one spot.
dispersed throughout the statute. Now in section 15, we've moved into a different area of Title 8. This is what we call the consumer protection statutes. So these are various protections that really relate to the banking division and other licensed entities. The first section, section 15, this language actually is no longer needed. So we've just said that it's been repealed.
What does it do?
It speaks to the application of the consumer protection chapter itself, and throughout the consumer protection statutes themselves, we've clarified exactly what applies to whom because of that definitional situation that I was talking about.
Okay.
So this particular APSA 10101, we don't need it.
Is this just a general application provision that now that you're being specific, you don't need the general one? Or?
Yes, this is a consumer protection statute, so it has special laws about like if you look at section 10-201 is the statement on a policy on financial privacy. So we get into how entities can handle consumers' financial private information. So it's more consumer protection areas than actually licensing.
Right.
So moving on to section 16, again, instead of using the term financial institution, because in this particular case right now, it means anything that DFR banking division regulates.
Okay, not just
We want, again, clarify financial institution means a bank. So we've adopted this new term and it's defined a little bit further, regulated entities. So that is any bank, credit union, trust company, or entity that is licensed by the banking division is subject to this statute.
that's the next
Yeah.
page.
Yep, the definitions for a regulated entity are found on page 32. And that means a person required to be licensed or chartered pursuant to part 2 of this title, an entity organized under the laws of another state that is regulated by its home state in equivalent manner. To an independent trust company chartered pursuant to chapter 77 of this title, a financial institution, credit union, branches and agency of foreign banks and subsidiaries of any such person. Turning back to page 31, we've removed the definition of financial institution because it was confusing. So we're now not using it at all.
When you use financial institution, it means bank though.
Exactly.
Yeah, and it looks like the next several pages, you're striking out financial institution and adding regulated entity.
That's correct. In section 16 through 21, that is the bulk of what we are doing.
Yeah, okay.
Let's see, so section 22. Begins on page 39. Well, maybe on page 38, we've just clarified again the Superior Court of Washington County, as well as the Civil Division of the Superior Court, which we talked about in the insurance section as well. We do have an amendment here in section 22. We got a little too zealous with our crossing out financial institution. If you can see, I'm thinking line number 12. We say if the person is not a Vermont person, what we mean is if the person is not a Vermont financial institution or a Vermont bank. So that we would like that actually to refer back to Vermont financial institution. Not person.
Wait.
If the person is not a Vermont institution or bank, then
Yeah, so
that's what you're looking for.
yeah, I guess maybe if I'll start at the beginning. So every person subject to the Federal Community Reinvestment Act of 1977. The only people subject to that act are banks. And that any bank is subject to that.
Okay,
So,
But
but the federal law says person.
That's a great question. I believe it just refers to banks.
Okay, no, I'm just saying, we are bringing this in line with the reference with what the word person means in federal law, where
That
we
is,
use per. This is defining what person means in Vermont, which gets it in line with what person means in federal financial regulations. Is that?
yeah, I think part of the issue is that in this particular section, it didn't make sense to use the new term regulated entity. Because the only people subject to this statute would be a bank.
So why don't we use financial institution?
That's a great question.
I think we're trying to avoid using the term financial institution right throughout due to a lack of clarity
Yeah,
of what that means.
But don't you define it somewhere else, or did you take out the definition too?
well, if you turn back, the definition in this particular statute under financial institution,
You deleted it.
we deleted it because it was not just a
We
bank.
deleted
referred
it
to
in this
many
statute,
different
so
things.
you want to make clear
Right.
in this statute. So you don't have to go switching back 500 pages to
Exactly.
find out what it means. Okay,
But this is weird on line 12. If the person is not a Vermont person. I mean, I understand what you're getting
is
at
that a
there,
real
but that
Vermont
is,
person?
it's a weird way to say.
Yeah, I know. So, there's different kinds of banks. So there are Vermont banks that this is referring to.
Yeah,
We're saying if you're not a Vermont bank, let's say you're a New Hampshire bank, you would still need to provide this information.
Is this a federally chartered or state chartered? Is that? Because there's federal chartered banks and state chartered banks, right?
That's correct. We don't have the ability to oversee national banks.
Okay, so these regulations are all for Vermont chartered banks.
This particular section would only apply to state chartered banks. It would apply to number one, all Vermont state chartered banks. It would also apply to any other states, state chartered bank that has activity in Vermont.
Okay,
And so that line 12 is saying if this entity covered by this person is not a Vermont person, then the requirements of this section shall only apply to reports that relate to its business in this state. Like I don't need to know what California says you're doing.
Okay.
I just need to know what you're doing in Vermont.
and when we use institution, financial institution, does that refer just to Vermont chartered banks or to nationally chartered banks?
When we use the term financial institution, it would be I guess I'd have to think through all of the changes we made, but generally speaking, it's only gonna be the banks that we regulate.
Okay, which are state charter.
Right, and a lot of that is just derived from the fact that the Office of the Comptroller of the Currency preempts us as a state from enforcing certain laws against national banks.
I still just find this a little confusing because in some cases you're saying financial institution only means a bank. And then you're
Right.
saying financial institution and credit unions, you're adding credit unions to be clear.
Correct.
In some cases, you're using the term regulated entity, and that's supposed to be broader, meaning more than the job bank.
Correct.
Yeah, anything you regulate. And in this case, you're using the term person to mean bank. So it seems
Yeah,
inconsistent.
yeah, and I think,
Is it here, is person means bank, but both state and federal bank?
like, well, yes, I guess under the federal law, all banks have to comply with that law.
Yeah.
But we're not really able to say that we need that information from a national bank.
Okay. Would you? If the idea is to bring clarity, it seems to be confusing.
Yeah,
I'm sorry.
it's confusing me. If it's confusing.
No, I think, I mean,
I
we used to
don't know.
hear in person in legalese documents, but I think we're having a hard time focusing on why this person is different from a financial and credit union or all regulated entities. So
Yeah,
Yeah, I mean, I think now that I'm spending a little more time in it, I think if we left the statute as it is and we just said every financial institution is subject to the Federal Community Reinvestment Act, you would be attempting to include national banks as well. That would include national banks.
mhm,
Okay, so we're trying to use a term specific to Vermont. We can't use regulated entity like we've done elsewhere in this section because that definition includes entities that are not banks, so they're not being
Right.
subject to this.
Hmm.
So we
And so
chose
this
the
is-
person as, it's not from hearing your question, it's not the perfect term of art to use.
okay, but it also has to do with consistency within this section or chapter. Because we're using financial institution,
yeah,
Correct.
and this is different than way we use it in the rest of the chapter. And person is probably the one legal term without creating a new term that
Yeah.
you can use. All right.
but you're saying in line, starting the end of line 11 to 12, that if it's not a Vermont bank, then it's would only apply to business done in Vermont. So you already are making clear that you're excluding national banks that aren't doing business here.
But they are.
Correct.
So
Why don't we
I'm still not clear why you need to use the word person here.
I will get clarification.
I think we
Okay.
could send you home
I have homework.
with your
Yeah.
thesaurus and see
Yeah.
what
My
we
son's
come up
college
with.
is not the only one with homework, so I.
Because somebody's gonna have to explain this on the floor.
Yeah, sure.
Could get interested. Okay,
Section 23.
Section 23, so we are clarifying the entities and who is subject to this particular statute. So, we've we've stricken any entity subject to this chapter and added a clarifying entry. Any person licensed, chartered, or otherwise authorized or required to be licensed, chartered, or otherwise authorized under parts 2, 4, or 5 of this title shall comply with 9 VSA chapter 4, which are the interest provisions.
And if anyone, I know in the House, there were questions about the parts. The parts do not show up if you look at the Vermont statutes online. They do show up if you're using a tool like Westlaw. I have an outline of what those are, but essentially 2, 4, and 5 are the banking division related parts.
okay. All right,
section 24, which is page 40 of the bill. So we're, again, as part of the clarifying of financial institution area, we've introduced a new term. Since this statute is entirely about providing credit and not discriminating against folks, we've used the term lending institution. So lending
Which could
institution
be a financial institution.
could be a financial institution, could be a credit union, or it could be an entity that has a license to lend.
Somewhere online.
Right, but they would still be subject to Vermont law based on these terms.
And lending institution is defined on page 42.
We go. So keep moving.
Okay, catching up here, all right, section 25 is on page 43. So this law is in reference to home loan escrow accounts. So if you have a mortgage and they take money from you every month to pay your property tax and your homeowner's insurance, this clarifies where they need to hold those funds.
Okay.
Section 26 is at the bottom there, or at least it starts. And then on line 10 of page 44, we've removed the definition for that refers to the definition of financial institution. So we removed it because we're clear that it is just a bank and doesn't need this other sub definition. Let's see, 27. Section 27 is the bottom of page 44. The commissioner may adopt rules to require Vermont financial institutions. So we've added that Vermont financial institution and stricken their principal place of business in the state.
Okay, so now you're back to using financial institutions.
That's correct. So in this particular, this statute, we only need Vermont chartered banks.
Okay,
And that's why we added the Vermont in front of the
Yeah.
institution. C, section 28 for return check charges. We struck depository institution and added financial institution. So again, here we mean bank or credit union. In section 29. See, this person shall apply to any person licensed, chartered, or otherwise authorized, or required to be licensed, chartered, or authorized under parts 2, 4, or 5 of this title. Very similar to what we've talked about. Section 30, this section begins an area that is how the department regulates reverse mortgages in the state of Vermont. At the bottom of page 45, we've stricken that definition of financial institution. We no longer need this. And we've just renumbered it and in accordance with that. In section 31, under counseling for these reverse mortgages, we use the term person because in this context, financial institution would have been limited to just banks. There are non-bank lenders that are licensed and allowed to provide reverse mortgages in the state. So in this case, just
It probably is a person who's just
yeah,
a human person.
exactly.
unregulated entity is too broad in this context.
Yes, because we've defined it to include entities that don't have the power to lend.
Language insurance company.
Let's see. Page 47, under section 32, no person shall require an applicant for reverse mortgage loan to purchase an annuity. Again, just cleaning up the language about financial institution.
Would that be to ensure the annuity would
The statute itself actually is a consumer protection. It doesn't allow someone who sells you a reverse mortgage
Yeah,
to also sell you an annuity, which can be a very high cost financial
Cost,
product. So we don't
yeah.
want senior citizens taking advantage of.
so they're going to they're gonna loan you money. But you're putting money into an annuity, right? You have to put money into an
Correct.
annuity
Correct.
before you can take money out, and okay. I'm just there were some creative things going on with life insurance and the like a number of years ago. You had an interesting thing that had to do with ACE for them, trying to remember it. But basically, they would buy your insurance if you were terminally ill. There were a few creative, back in my NCOIL going days, there's
Okay.
creative things. All right,
All right. Bottom of page 47, we're now in the section 33. Again, one stricken financial institution in favor of person.
Then you've had a definition of a Vermont financial institutions in this section.
Yes, we do. That definition currently exists in the state law.
Is this only for? Guess I'm getting very confused by this.
Sure.
Out of these terms.
Sure. Where we've used the term, we've intended to use the term as written. I just wasn't able to help you explain that particular area.
Maybe we need a key for
Yeah,
when you're
sure.
using them, when and why.
Sure. Absolutely. This and on page 48 with section 34, this is actually in the banking statutes themselves. So if you look at line 14, we've added the word financial. That was actually a Scrivener's error originally. There is not a special purpose institution in Vermont law. There is a special purpose financial institution defined elsewhere. So it was just not a full reference being made there.
But you're using.
Could go back to the preceding paragraph regarding the requirements for reverse mortgage companies.
Sure.
My understanding is the definition that you have there, the description that you have there pertains to those reverse mortgages that HUD approves.
Mhm.
But by that paragraph, you prevented jumbo or other kinds of reverse mortgages. Can you tell me why you did that? Was it simply consumer protection or?
It predates me. I think that's been in.
It was changed.
for
It
a
was
while.
in statute for a while. And there was I know a proposal, I think it was like 22
Okay.
to change that. Because my understanding is that Vermont is the only state in the union that has that restriction, at least in that fashion.
Okay, I'm not aware of that, but I do know that we did only allow reverse mortgages subject to the HUD.
Yeah.
So yeah, the private.
So the
label
jumbos and
jumbos-
the larger ones, and so
Larger ones.
it restricted the ability of a homeowner to get the maximum money out that the market would allow, and the kind of things in HUD. I understand the only thing HUD does basically provides, in fact, some backup insurance,
Sure.
which theoretically protects the borrower, but it restricts the ability of property owners with property value higher than the HUD limit, which is relatively low in comparison
Yeah.
to what's being offered in the market elsewhere.
Okay.
And thereby, in effect, forces owners who need money to sell,
Yeah.
which they wouldn't ordinarily, and that has, some follow-on effects.
Sure.
I had mentioned it, I think, to Kai at one point, and I just haven't gotten around to, providing some additional information that you
Okay.
can request, which I will do.
Yeah. No, I remember that. I think I forgot exactly. I did
Yeah.
respond.
Yeah, I got your response.
Okay, good.
Yeah. Go ahead.
So yeah, I mean, it's a policy choice for sure.
Yeah, sure. No, I can understand the protection issue.
Yeah.
What are you,
Just
as I saw that, whether there was anything else involved other than what you had written previously?
Yeah, we didn't make any other changes based on that conversation that we had.
Okay.
I'm
Okay,
happy to talk about it later if you want.
that would be subject for entire bills.
Okay, section 35.
And the meetings of the governing body.
Yes, 35 meetings of the governing body. So sections 35 and 36 say the same thing. They're just for two different types of bank. The first is for a stock bank. We are now saying that the board of directors of that bank only needs to meet quarterly, as long as they have an executive committee of the board that meets monthly, and the minutes of that executive committee are ratified at the governing body's next meeting. Section 36, the same language for a mutual bank. Mutual bank is a bank that's owned by its depositors, not shareholders. We also have adopted that language on page 58 for the credit unions as well. That's section 39. Questions on that?
No.
All right, section 37 is the juicy one. So this is a bank's loan authority.
What page?
Sorry, page 50.
Page.
So as it exists in statute today, there are two real rules that govern a bank's loan authority, how much they can lend. The first is a requirement that anytime a bank would like to make a loan that is more than 10% of its capital, that loan needs to go to the board for approval. Now that process can be cumbersome, especially in this day and age when you have online competition and you kind of need to move fast. So what we've asked in all of this language is to remove that 10% requirement in favor, if you turn to page 51, paragraph E, in favor of a situation where the board of directors of the bank writes a loan policy and they determine the terms under which they would like to evaluate a loan for approval. So we're giving the financial institution board the power to sort of set their own risk limits and then also make those determinations for themselves and be less prescriptive in the statute. And that was a request from industry that we got. This section wasn't actually in our housekeeping bill. This was something we did work with the industry over after that we had put it all together, and we'll share more on that specifically.
Loan institutions. Suddenly, there's a whole lot of loans or advertisements for SoFi comes to mind. They're online. You can get mortgages. It looks like you can get loans. Who regulates them? Are they regulated? If someone in this state. Okay,
We do, DFR does. So if you are not otherwise exempt from our licensing standards, so basically you need to be a bank or a credit union, or there's some other exceptions. But if you are just a standard non-bank entity in California, if you would like to offer a mortgage loan to a homeowner, you need a license from DFR. And then we have a few hundred different licenses for entities like that, including SoFi.
all right.
This statute doesn't apply to those companies, though. This statute only applies to a Vermont charter bank.
Okay.
This is the question, in terms of these other companies that advertise generally for loans outside non-Vermont companies, what's your experience, Vermont's experience with dealing with companies like that? Is this a market that is going on and is soliciting people and taking loans without your knowledge?
Generally speaking, I don't know how long you've all been on the committee. My predecessor, Tom Candon, was instrumental back in the day after the Great Recession of passing language related to the National Mortgage Licensing System, and then the last 2 years further. Now all states use that system to keep track of all of their licenses. And so we have our mortgage lenders, auto lenders, general lenders are all subject to licensure through there. So we also get to see if a company reports activity to us that doesn't have a license, and we can take an action. Generally speaking, more entities will get a license in Vermont and not actually write business here, just because it's easier to get the license and be protected. But occasionally on the rear side, we do run into that situation. And we have the powers already in statute to take action as necessary.
Some of us do remember Tom Campbell. And the age of exotic mortgages, which fortunately for my
Some troubles back
didn't
then.
go in for, but nationally, yeah, we all remember the crash. There were exotic mortgages.
On small d there, limitations. Just that language, are we talking about one loan can't exceed 20% or their portfolio of loans? What's that language?
So yeah, the second part of the changes that we're making here relate to what I would call the loans to one borrower rule. So in existing statute, we say that a bank cannot make a loan to one borrower in excess of 20% of its capital.
Okay.
Okay. Further on the next page, there's definitions of how we look to situations where maybe, I have two LLCs and I borrow money from each of them. And how you would look at those together holistically. Industry was running into a situation where there might be two separate LLCs with two separate repayments and two separate businesses were unrelated, other than they may have just a similar corporate parent up above. And the way that the existing law is written, we would have to look, or they would have to look at that as one borrowing. What we've proposed in this language is we've adopted some language from the OCC, the Office of the Comptroller of the Currency, who regulates national banks. And we've included some standards or we've included their standards that are applicable to national banks to a Vermont chart. Okay. So if you see in that sub D, we've added language after the in excess of 20% of its capital, or to a corporate group in excess of 50% of its capital. And then define what the corporate group means. So we've given them a little bit more lending power, but still wanted to make sure that we didn't give too much. And that, again, that language is in the OCC.
And what is it's referring to, the lender or the borrower?
The corporate group would be the borrower,
Okay, so
or the group of borrowers.
on line 15, 20% of its capital.
Oh, sorry, its capital is the bank's capital.
Okay. So a bank could lend 50% of its capital to a group of a corporate group, one corporate group.
There's further clarifications elsewhere in the statute, but theoretically, yes.
Wow, that's a lot of its capital to lend from one group.
Right, but there would be no interdependence among any of those, so they would be all standalone entities that just have sort of maybe a common ownership up above that are really totally separate
That's like
entities.
using half your eggs in one basket.
Theoretically, yes. I mean, most banks are lending out probably in total 80 to, in excess of all of their capital too. Just in terms of the number of loans that they're making.
I know, but they're spreading out their risk by lending it to a lot of different people.
Sure.
So like lending it to just one group seems, or lending half what you have to one group seems like
Your exposure.
it's not spreading your risk out. And I understand that they might be not. This is where you want to use the word person, but you can't. So, I don't know.
Yeah, so also a few, hopefully this will help reassure you. I mean, also keep in mind that DFR or the FDIC is in these institutions every 12 to 18 months, scrutinizing those decisions that they make and looking at these large loans, especially their largest loans. Those are always going to be looked at.
Mhm.
So we do have comfort because we are able to see that activity and see the decisions that they're making all the time.
Having similar concerns with this, can you
you said this came from industry, but can you further normalize this? Is this common practice in other states to relieve this, to raise this amount that can be in a single loan without board approval?
Yeah, so, this wouldn't necessarily be without board approval. They would have to have a standard that says the board needs to approve these loans, number one. Number two, this would not be a loan to one borrower of 50% of its capital. So the example that industry came to us with they had a private equity firm that owned two separate marinas. One marina, I think, was in Chittenden County area, and one was in Addison County area. They were, each was a separate LLC. Each had their own cash flow and their own business model and their own loan with the bank. Because they had this similar ownership of the private equity firm, the bank was restricted from making a loan to the second entity. Okay, so this way, the two entities are looked at separately. And so they're going to be making the decisions based on the cash flows and the collateral for each of them separately, subject to the 50% corporate good limitation.
Okay, but then why are we taking away the total loss to loans? There were the last sentence there with requiring the governing body to access to 10% capital.
That was I started this section by talking about how we traded that particular language that requires the board to approve any loan over 10% in favor of a standard where the board of directors sets what their risk tolerance is in their loan policy. And they're the ones that determine what level of lending activity they need to approve at the board level.
I guess the last thing I'd say is I know this isn't the same thing, but I just think of the Chittenden Solid Waste District that recently released $3 million in the fraudulent payment to vendor. I'm curious if that 10% is a good safeguard before a loan can then be made without governing body approval. So I don't know why we want to just remove that one little stopgap measure to make sure that there's some corporate accountability for such a large transaction.
Yeah, no, I did hear about that particular issue. As far as I know, that wasn't really related to a loan. That was more construction finance sort of activity.
This is opening up the possibility of much larger amounts of money to change hands.
Sure. I mean, and banks are also in the business of wiring and transferring funds all the time. So they do have controls for that particular set of.
Yeah, but I think to Senator Chittenden's point is that we're at the same time, we're upping the percentage that can be loaned out.
Mm-hmm.
We're getting rid of the chatter. And I hear you that banks are going to create their own internal policies about what but that, some are going to be riskier than others. So maybe they've set it at 51% or something like that. And I mean, the marina thing, is there really a lender that wanted to lend half of all the money they have to two marinas in neighboring counties?
It's really going to be for the smaller institutions that don't have a lot of capital. So, if you're a $1 billion bank and you have $100 million of capital, you're going to be able to make those two loans very quickly.
Yeah.
Very easily. And like if you're going to build an apartment building, that's, it used to be $5 million. Now it's going to be $10 to $12 million. So, I think as the deputy commissioner, I was okay with this language because, I know our staff is in there all the time. I understand that it's a limited situation that's going to be applied.
We have qualifiers so that this only applies to entities with a certain amount of capital, so that it would really just benefit the smaller banking institutions, and we wouldn't necessarily have as much larger end exposure for medium to large size banks, all of a sudden having massive amounts of money being issued in loans without court approval.
Yeah, I think you'd want to hear from the bankers on their thoughts on that.
Yeah, maybe hearing from them just in general about this section to make me usually calm and me feel better.
So we will ask Mr. Delia. We haven't done anything to upset him in a while, so we'll invite him in.
And like I said, this wasn't really part of our original proposal, but it was language we had worked with him and.
Okay, and we'll
his
hear their
constituent, you know,
side.
So we were okay with it and got added.
And this is,
Okay, so it's not your proposal.
Is it-
That's interesting.
Well, it is something we support, but it was not originally from us. Exactly. Just providing history and context. In section 37.
yes,
Section 37, yes.
I did ask a question, but I don't remember an answer. I'm curious, do you know how the landscape of other states compares on this front? Are we out of step and the synchronizes with other states?
I'm sorry, yes. So yes, this is language that is for all national banks. It also is comparable to what's in the state of Maine as well. I didn't do a full nationwide search.
so Maine is not known to be financially.
Yeah, yeah. It's a competition.
Liberal or
I would-
loose or
yeah.
unregulated. They're conservative New England,
I would agree.
not from. Okay, we'll look at them. We'll hear from the bankers. Now, in this one, is this credit? This isn't credit union.
No,
This
this,
is bank.
this is only Vermont. chartered
Financial
banks.
institution.
Vermont
Yeah,
financial.
I
institutions,
just
that's
wanted to
correct.
make sure
That's
Vermont
correct.
person that's not a Vermont person.
that is true.
We have not proposed any changes to the credit union loan and borrowing rule.
Okay,
All right, so.
Page 57 is section 38.
Page 57, we're in 38, so now we are actually in this body of law that affects.
Wait. You skipped over. I know, but the stuff below that you said clarifies this. What a 50% is. Percentages on page
52.
52 and 53.
Yeah, so that is all related to the to one borrower situation.
Okay,
And so this talks about how, in that corporate group scenario that we are referring to, if there was any financial interdependentness between those two borrowers, those two LLCs that we're talking about,
Mhm.
you have to count them as one borrower.
okay.
okay,
It's only applicable to the situations where there is no interdependence. So they are truly standalone entities.
You got
in of themselves.
places, they're both taking out a loan to build the same shopping,
They would both be considered one borrower
one borrower.
under existing and the law.
Okay. Okay. Which, yeah, does spread your risk. If you've got. You're only loaning to one partner in the shopping mall and somebody else is loaning to the other.
That's correct.
Okay.
So, on page 52, paragraph B talks about the common enterprise shall be deemed to exist. And then it sort of explains all of the situations which would apply. I can go through that, or we can hear from the bankers.
if it's their language, let's hear from them.
Well,
Have them justify it.
and then the next page seems to be decapitalizing the word embedded.
That would be a stylistic choice that I'm sure
Okay,
someone smarter than me could explain why we do that. All right. So I think then we're now on to section 38, which is now in the credit union body of law.
What page?
Sorry, 57.
Okay,
And we just added language to clarify the applicability and the meaning of this section for credit unions and the parts of Title II, as we've done 2 other times elsewhere. On page 58, we have section 39. That was the meetings of governing body standard that I mentioned was the same as what we've proposed for the 2 different banks.
right.
On page 59 in section 40, we've added paragraph B there. So that what this clarifies what we've always believed in the banking division, but that what this says is that as long as you have a joint deposit account at a credit union, as long as one of the two people on that account is a member of the credit union, then it's legal and it should be treated as that. As you may know, credit unions really should only serve members,
That's right.
member base. And so this just clarifies that a joint deposit could be held with a non-member. Section 41 does the same concept for the loan side of their balance sheet. So it basically says that a co-borrower on a loan can be a non-member. Again, these are two areas where we've always believed that. It's no longer federal law, but that's true. We just wanted to clarify it, and so did the association. The bottom of page 59,
Should have the credit union people in too.
it's credit union day. in St.
I
Louis.
know.
We could-
Joe is not here this year.
Today?
I have to find out what's in the edit.
There's a reception in the Cedar Creek room right now.
Whoa.
They have ice cream.
No ice cream.
Chicken.
There might be adult beverages. Not sure.
Adult beverages.
No beverage, no ice cream.
Not in the room or not at all.
They can't leave this committee.
Oh.
Or
And the
there's some
lose her quorum.
devils that serve ice cream at 3:30 in the afternoon.
No
And my
press
committee
conferences either.
disappeared. No ice cream and no pizza. We stay here to finish.
Is it possible to get deliveries?
Ice cream.
That has happened.
At the bottom of page 59, we struck language that we don't need. It says the governing body shall establish a written loan policy in accordance with this section. It's actually on page 60. It's already in there. So we're just cleaning that up a little bit.
Oh, are we? Almost. to the-
We're almost there.
Wow.
Yeah. Even with me fumbling the loan authority
That's okay.
sections.
You didn't fumble it. We just asked two questions.
You asked me good, hard questions that I
Yeah.
hadn't pre-thought about. That's the
Yeah.
hardest stuff.
Gabby just doesn't.
It's good.
Yeah.
Trust and verify. I tell my examiners that all the time.
Exactly.
We appreciate a healthy skepticism.
Yeah.
Yeah, well, I'm here for that.
We will invite the banks, credit unions in.
My middle name.
And I will make sure I come back whenever you have me back in, if I'm available, just.
Well, think if, once you get time to kind of generate the concern, think about it, just come back and tell us if you think you want to make changes or you don't.
Okay. Let's see, on page 61 at the bottom, is section 42. This state law, is how we process and handle the merger of two credit unions. When what we've proposed in this language is that when there are two state chartered credit unions that are merging together, only the credit union that is merging out or will no longer exist after the merger needs to approve the merger. Under existing state law, the fields of membership of both the merging credit union and the surviving credit union need to approve the merger.
This would have shown up in East Rise, which was a fairly contested merger. There was a lot of local feeling about it.
There was. So, that merger really, because New England Federal Credit Union is a federal credit union, their field of membership didn't need to, under federal law, didn't need to approve that merger. Only the field of membership at VSECU needed to approve that merger, and they obviously did because they did merge. So in existing state law, if both of those credit unions were state chartered, both fields of membership would need to approve the merger. And so we would like to align the law with federal law so that the continuing credit union is not going to have any changes. They're going to continue to exist and their members will be unaffected by the merger. So we don't see the use in requiring that field of membership approve the merger. The board of directors are experts. They've done their due diligence and they've gone ahead and do it. But the merging credit union would still need to have their members approve the merger under this new standard.
Nobody came forward to testify in the House.
They did actually. This was the one area where they gave me a lot of questions about that. They were concerned, like you were, about making sure consumers have the ability, the members have the ability to voice their opinion.
What if there are two different credit unions that are merging to become a wholly new credit union?
Well, that's what one.
If if we're talking about two state credit unions, under existing law, both of the credit unions, separate fields of membership would have to approve the merger. For this new standard, we would like to use the sort of law or the standard that's in federal law.
No, I understand that, but what if there's credit union A and credit union B and they're merging to become credit union C?
Well, that's what they did here. It's.
That's what every merger basically is, yeah.
Right, so then both of the merging entities would be changing.
Yeah, it's not, I wouldn't really think of it as a third credit union involved in any situation where you're talking about a merger. It's really like, think of it as the merging credit union, which will go away,
Yeah,
and the surviving credit union, which will continue.
no, I know that, but what if neither of them continue, that what gets created is something completely new?
Well, that would be a whole nother statute where you'd be essentially applying for a brand new credit union. You'd have to get our approval.
Oh,
You'd have to get NCUA's insurance approval. Like that would be,
okay,
that would
Yeah, I think
not
this
be
one
very
they just
efficient way to
changed the
go
name.
about what you're talking.
okay, so just changing the name doesn't mean that there's a different credit union.
No,
Like
no,
a
no,
different,
that's
like-
still,
It's got a nice new logo.
yeah, it's a
That's
nice new
pretty.
logo. It's still the same charter. It's still the
Got
same legal rights and responsibilities they have from day to day.
Got it, okay.
And if I recall, correct me if I have this wrong, but if you have without this provision, so you need both credit unions to have a member vote. If you had a state chartered credit union, if they were to be acquired by a federal credit union, only the state chartered, the one that's going to be dissolved, would be voting. And so in some ways, having that vote on both sides puts state credit unions at a disadvantage from acquiring other state credit unions.
Kai Sampson, Commissioner, I think that's a key point in terms of leveling the playing field.
Yes.
Deputy can tell you that smaller credit unions, sometimes have issues with scale, so, mergers do happen. And you don't want a scenario where, there's an easier path, you know, where you want an equal decision on whether you're merging with a federally chartered or another state charter. At this point, there's not parity in making that decision in terms of the work to go through. Is that fair?
Yeah, that's very fair to say. In addition, in the scenario that we contemplated with this new language, DFR still has to approve it too. So we have
Okay.
that sort of like other check and balance involved.
And we have some very small credit.
Yeah,
Yeah, we have less and less. Our smallest credit union, St. Patrick's Parish in Fairfield, just is in the process of finishing their merger.
sounds like we're talking about school districts.
Yeah, they were so small, they didn't actually handle cash for you. They had to write you a check for your deposit so you could go somewhere else. Like,
Wow.
Because they
it
came up.
was in John's.
Yeah, they were generally.
Yeah, it was in general employment groups, so like this was a church credit union, a lot of those, and
I
so.
never heard about credit unions till I went to a mill town outside Pittsburgh. And they were huge down there. I mean, every different occupation had its credit union, and that's how they got credit. And
Big in the
I
Midwest.
got-
Yeah, my mom tells me that they bought their first TV when my grandfather got a loan from the credit union.
Yeah.
Yeah. So, the cash available to working America.
So are we comfortable with the merger provision?
So,
We have one more section, and then I will just briefly follow up on something that came up earlier.
Great. Section 43 is on page 64 and 65. This section of law is entitled 9, and it's language that talks about when you take out a loan, how the funds need to be dispersed. And so again, as part of our clarifying and using the right terms in the right way, we've just on page 65, clarified in paragraph F the definitions used when we say financial institution and when we say. Those actually are the true definitions because they'll refer to the bank and credit union sections.
And then one other item. There was a question earlier about the restitution fund, and I'm going to pull up, we have a press release from the most recent action that is available on our website, just so folks can see it. So this was Chadwick Investors. This was from 2024. 21 investors who lost significant portions of their retirement savings due to their investment advisor's misconduct. Chadwick was ordered to pay restitution, but has failed to pay the victims to date. And so the fund allows the department to pay victims of securities violations a portion of their losses. The restitution was ordered and not paid. Awards are limited to $25,000 or 25% of the unpaid restitution, unless the victim meets the definition of a vulnerable person, in which case it's 50,000 or 50%.
And does the department take, I mean, yeah, I think I know the answer to this, but what kind of legal action does the department take to continue to try to get the money from the financial institution?
I think the court orders it,
The court, yeah.
and other than that, I think
There is a subrogation section in the statute, but that's something we'd have to check with the securities division on.
And is there any, maybe this is a court thing, but so that Chadwick Consulting or whatever the company was that did this, do they lose the ability to be a licensed financial institution?
I actually sent you this. So
Perpetuity,
it's in
you
your,
did, okay,
yeah, and you can see the order itself, and
okay, cool,
yeah,
thank you.
they're done.
The person,
and-
institution?
And that is, you know, communicated through all 50 states.
Okay.
Those type of enforcement actions. I believe this was in New Hampshire.
Yes, it was joined with New Hampshire. We have a recognition of the New Hampshire Bureau of Securities in the press release.
So
So
was this a fraud?
was for violating fiduciary duties to clients and investing in unsuitable high-risk products.
Was this kind of thing that would be potentially subject to any criminal penalties, or is this simply a regulatory violation?
We don't do the criminal stuff.
Do you refer?
You'll see by the date that only Aaron was at the department at that point, 2022. And he was focusing on banking, but we can look at the order and I'll ask securities.
It would be interesting because I've seen some other things in state government in which there has been what looks, at least to me, like a particularly egregious violation, but it's only been dealt with internally as an issue involving the department where the violation occurred and that department's rules and regulations. But there is clearly avarice involved in the description of what the individual or individuals have done. And I know in some other departments, I've seen these kinds of things happen in which they deal with the department's regulations regarding recovery, but they don't deal with the criminal penalty that someone has obviously stolen things. And so I'm just curious if that happens in these cases, or even potentially happens in these cases. And if there's a process to identify what appears to be a criminal violation and and we see that it is dealt with and at least referred to an agency that does have the ability to act.
Right.
But that's a great question, and I'll check with our securities enforcement folks and we'll get back to you on that.
Okay, thank you.
2 hours. I was
Banking
gonna
and
say,
insurance.
thank you, everyone.
And I think the House did it in about the same amount of time, but I think they did take a break in the middle. So well done.
We're tough, and we're getting out early. Some of us have the chairs meeting, which date hasn't been set. So thank you. We've got a couple things to think about. We'll have banks, credit unions. I don't think we're doing it really.
And to the extent you'd like us to come back and talk about crypto kiosks, please let us know.
Okay,
Let's do it.
yes, that. You
Yeah,
can come back and we'll have, let us know when you're ready. Just let Charlotte know or she can contact you as well. To know what is going on would be very helpful.
I think the real question is whether or not, the experience in other states, even though we may not have had serious problems, is enough of a lesson to us that we should act as some other states have acted, and eliminate this before we have the problem rather than waiting until we do.
Yeah, I mean, I can report to you now, it's been fairly quiet, but that's because we only have 2 machines.
Yeah.
No, look. The number of machines equates to the level of activity.
yeah,
Yeah,
exactly.
we have 2 machines in one company.
Might be better to nip this.
We have kind of discussed internally, like the one way we look at financial products is, are we depriving someone of an important avenue or something, and it's financial markets. And with crypto kiosks, hard for me to think that the lack thereof deprives someone from access.
They can still go online.
Yeah, for about 1/10 of the transaction.
Yeah. Yeah.
Well, yeah,
Are
what we
we
could do
deprived
is have to do the transactions.
So just the little old lady who doesn't know how to get online,
Mhm.
but can feed $100 bill into that kiosk.
And it's hard to imagine that scenario.
Yes,
That profile of an individual wants to set up a Bitcoin wallet.
Yeah.
okay. Thank you, everyone. Been a long haul.
Thank you all.